It is July 28th of 2026, and this is the Court Gallery. Today we start with a woman who drives to court for a no license charge without a valid license, and then tries to argue the rules don't apply to her. Then a defendant games the system over 3 different settings by firing 3 different lawyers before simply not showing up. Judge McNally is not impressed. Finally, we're with Judge Simpson as a man on a tether explains ghosting his probation agent for months with a classic "my phone broke" excuse. And things really heat up when the defendant's mother steps in to participate. These judges are not buying these stupid excuses today. All that and more starts right now.
Against it, Vasilios Grios.
Right, Your Honor.
713-422. Somebody sent me what they call the victim's impact statement, and they said they were going to be in court.
They are.
Who is it?
It's Karen right here.
She shouldn't be. I mean, go ahead and state your appearance.
Sure. Good morning. May it please the court. My name is Matt Savage. I represent Vasilios Grios, who stands to my right.
Your name?
Name is Vasilios Grios.
She's almost. Did you read this statement?
I did, Your Honor.
The only reason I'm saying this is she's almost incriminating herself for filing a false police report. I don't want her to come up here and start saying things on the record. So, I mean,
I agree with you, Your Honor. I felt the same way. If I would have known that was being submitted beforehand, I might have.
I mean, I'm reading this thing and I'm saying, first of all, she's not a victim.
Right.
At least there was no charge filed against Mr. Grios versus her. And then I'm saying she is completely incriminating herself.
Right.
And I don't want to be a party to that. I shouldn't be a party to that. So I'm just going to pass along here. She doesn't have the right to speak anyway.
Right.
I'm going to ask you, first of all, but I'm not real excited about Mr. Grios's behavior here. Okay? I got an officer in a report saying he punched him in the face. So I'm just telling you, we got a problem here. I don't care if she called and should have, or should have called and called. We don't hit police officers in the face.
Your Honor, I agree, and we had this conversation when we put the plea on the record. You were disappointed then in regards to the.
I'm not disappointed now. I'm uptight about it because we don't have the right. We don't have the right, Mr. Grios. I don't care who you think you are, to hit people for doing their job. We don't have the right to do that. If you don't like what I do, you're going to come up here and punch me? I don't blame you for being quiet. Have you had a chance to review the report, and are there any material additions, corrections, or deletions?
I have, Your Honor. There is just one correction, which is the defendant's statement. That statement was actually not submitted by my client. He does desire to allocute. He has the written statement that he's probably going to read to the court because he doesn't do public speaking and he's never written a statement before. Judge, the rest of the report is accurate, so there's really no deletions to make to it. I would ask the court to one just strike the defendant's statement and actually withdraw that statement that was submitted.
I guess I'm not following. He didn't write a statement here, did he? All I got is a blank version of offense. Is that what you're talking about?
Well, no, they've stated that there's a statement attached provided by the defendant. He did not provide a statement. He has it with him today.
Okay, I got you. I was confused by that too. Okay.
So that would be the only correction.
Okay.
Your Honor, I have a very short allocution. I know you heard what I stated the last time we were here at the pre-trial. in regards to me knowing Vasilios for, I think it's almost 18 years now. His daughter's in the courtroom, his son's in the courtroom, and I think his son's wife is in the courtroom. His daughter, who's all at the left, her name is Abby. And my daughter and her played hockey together for 18 years. They played Bell Tire, Chicken. They competed against each other in college. They play on the same team now. So I've known this family for 18 years, and I'm honored to say that they're friends of mine. You know, Vasilios may have some anger issues, but in terms of actually physically using any aggression towards anybody, I would like to state for the record, Judge, I reviewed the body cam footage 10 times. They were incidental hits. He got tased, and when they were pushing him down and arresting him, there was some flailing done. He never closed his fist and punched anybody intentionally. I have it on my phone if the court would like to review it. I'm letting you know as an officer of the court. You know I've been in front of you since 1994, since you've been on the bench. He did not physically attack anybody. No police officer, no one. And you could read that statement that was submitted. There's limited contact there. I think once you hear his allocution, reading his statement, I think you'll get a better picture of what type of individual he is. I know looking at the report, I've read it, the officer said he was punched. I'm not seeing that. He still committed the crime of resisting arrest. We're not denying that. But his behavior was belligerent, and he was just avoiding getting arrested. It's essentially what he was doing. He was holding his door.
Let me see that video. Do you have it when they were on the stairs?
Yes, you are. May I approach?
Yeah. Is there a way we can put that on the screen here, Lisa? Do you?
Judge, what I did was I just videotaped it off of my computer because
That's
I'm not
fine.
tech savvy, but
If he sends it to me by email, I can screen share.
I mean, there've been charges he's had. He's never had anything since 1980 that he was convicted of. I'll grant you that. He had an OWI and 2 domestic that were dismissed.
you might want to have her watch it first before she puts it up, just in case, some video of me playing hockey comes up. That would be awful to watch.
Not as bad as my golf game.
I don't have it yet, Judge. I'm still waiting.
Wachowski. Where's Wachowski? Jacob Allen Wachowski, 25W700782. Is this somebody, one of these lawyers? Is this one of yours, gentlemen, or not?
He's proper.
Why don't you
No,
have a
Judge.
seat right at the table there? Recalling Vasilios Grias, 26W713422FY. All right, Lisa, I'd like you to play that for me. I'm assuming we're all set. Mr. Savage, your name?
Again, for the record, may I please report, my name is Matt Savage, and I represent Vasilios Grias.
Your name again, sir?
Vasilios Grias.
Can you play that for me?
Judge, I still don't have it.
Did you go down and work it out with her?
Yes, I did. I was coming back to tell you that for whatever reason, it's not transferring. I have it just copied on my phone. It's only 20 seconds if you'd like.
Let me see it. Pull it
May I
up.
approach?
Yeah.
Sorry, Judge, I'm so not tech.
That's okay.
It's ridiculous.
Let me see.
Okay. So it'll just play over again. This is like the tail end. So take 1 second.
That's all right, Beck.
Which is definitely.
I mean, go ahead.
Okay. Thank you.
All right. We've already started the sentence.
Yeah.
There's no material additions, corrections, or deletions, except for the fact that it says see attached statement, and he didn't give an attached statement.
That is correct.
He has something he wants to read.
Yes, Your Honor.
Go ahead, sir.
I spent a great deal of time reflecting on then June 6, 2026 on how to express my serious remorse. I take full responsibility for my actions and understand the seriousness of what occurred. I am deeply sorry for the conduct and for the impact that it has on everyone involved. I apologize to the officers that evening after the incidents. They were there to protect and serve. I made their job difficult, dangerous, and the reason I want to apologize again. The experience I've had profound effect on both me and my family. I respectfully ask the court to allow me the opportunity to continue caring for those who depend on me. Help support my elderly mother, whose health is declining, and I play an important role in their lives, my family, and my friends, and my significant other. They rely on me. I'm committed to continue for them to be, and I am committed to being a better role model. On July 27, 2020, my wife passed. Suddenly, unexpectedly, at the age of 58. Losing her was the most painful experience in my life. Loss continues to affect me every day. I do not offer me grief as an excuse for my actions. I have come to realize that emotional pain I carry since her passion has affected me in ways that I fully do not recognize. I now understand that I need professional help to process the grief and become a healthier, better version of myself. I'm fully committed to participating in counseling to better understand, manage my emotions and anger, and to ensure that the incident like this will never happen again. I do not want this single incident to define my character. Instead, I choose to review it in turning point, an opportunity for accountability, personal growth, meaningful change. And I sincerely apologize to everyone affected by this incident. I accept full responsibility for my actions and am committed to making lasting changes in my life.
Did you write that?
That's what I did.
Well done. Well done. Anything else?
No. Well, just simply asking for to adopt a recommendation for conviction.
You did, it just appears to me that you did swing on the officer. Video's not that clear. You should have never done it. He's got some medical conditions. I don't know why they're recommending a psychiatric evaluation.
But just because he wants counseling. So.
He wants that?
Yeah, he wants it, he's gonna do.
Well, I mean, I want him to go to anger management.
Yes.
That's different than psychiatric evaluation, mental health treatment.
Yeah, I don't think he needs psychiatric evaluation, but to just get individual counseling in addition to anger management, that's.
Is there anything that prevents him from doing the court work program?
You are, I know his physical health is not the greatest, but do you think he can handle some physical community service, which would be manual labor, but not too harsh?
Will do anything I have to do.
I think he can handle that. He is on disability because he had a back.
I don't know. He's got some issues.
Yeah, he had a back,
All right.
that caused him to be on disability.
I don't want to press it. I'd feel horrible if something happened. What you did was wrong. I sense that you understand and recognize that. It was well written. I do sense that you have a lot of remorse. You've not had any conviction for 46 years. You cannot leave the state without the consent of the court or violate any law or ordinance of any unit of government. If you change your address, your place of employment, or home telephone number, you must notify probation. You do have to report as directed. No firearms. You don't want you to possess firearms or dangerous weapons. You don't have any? Anger management program with 12-week follow-up. If you want counseling in addition to that, you can get it on your own. No contact with the victims, Cameron Pazlako or Tom Timmis. You cannot write, phone, see, text, email, or communicate with them in any form or fashion. $200 in fines, 200 costs, 75 victims' rights fee, $50 justice assessment. So fines and costs are 5 1/4, screening fees 60 for 585, probation fees are 300 for a total of 885. I think I said 15 months probation. I did
You
say
did
that.
say,
I'm also going to order 7 days jail credit, 1 serve 6. I'll let you serve those by way of community service. So 48 hours of community service, and I'm gonna give you until, let's see, this is July 28th. I'll give you until September the 30th to complete your 48 hours. You may be eligible for early discharge pursuant to statute. You've done everything and there's no violations within the preceding 90 days in 7.5 months. You can come in here and seek, early discharge. If you violate, your probation could be revoked. You could be incarcerated for 1 year, 365 days with credit for any time served. You have 21 days to appeal, 14 days to apply for a court-appointed lawyer for purposes of appeal. Do you understand that? Well, I sense that he's remorseful. That's a good thing. I don't see that a ton. Okay, that's what we'll do. Can you pay this today or does he need time? I suspect he needs some time.
You can pay the $585 today, then.
Well, it's probation fees too, 300,
You
885.
can pay them monthly, as you can.
You just tell me what he can pay today.
I pay the $585 and finding costs, and then it's better making payments for.
I'll just make it $40 a month then, okay? $585 today, $40 monthly, and I'll start that beginning September 1.
Perfect.
If something happens and you need more time, you call the court, we'll go on Zoom. I'll give you an extension, or you can come into court and I'll be glad to give you an extension, okay? But it has to be on or before the due date, 8:30. Just don't ignore me, all right?
Thank you, Trevor. Thank you.
I wish you well. Floyd, Cassandra Sierra, Jean Floyd. 26M718-266A and B. Good morning, ma'am. Your name? You're charged with no license and speeding. You have the right to an attorney. If you would like one, I will give you one. Would you like an attorney to represent you? Okay, I'll go ahead and arraign you and then I'll send you to the prosecutor. It is alleged that you did on June the 23 of 26 operate a motor vehicle on I-75 northbound near Woodruff and Brownstown at 11:58 a.m. And they think that you did not have a license. That is a misdemeanor, punishable by up to 500 fines, 90 days jail, costs, or all those. And then you have a speeding charge here of 1 to 5 over. That would be limited access, 0 points, but it would go on your record. Do you understand that?
Yeah.
Did you sign, read, and understand the advice of rights form here today?
Yes.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
All right. Yep, you still wish to waive your right to a lawyer.
Yeah.
I'm entering a not guilty plea. I'm going to let you go talk to the prosecutor. I'm giving you a $500 personal bond. You didn't show up last time. You need to make sure you show up. You cannot leave the state without the consent of the court or violate a law, and you must appear in court as directed. Do you understand all that?
Yes.
So I'm going to send you to the prosecutor. He'll bring the file over and you talk to her, see what you can work out. Okay?
Thank you.
Good luck. Cassandra Sierra Floyd, 26M718-266A and B. You should have been a lawyer.
I should have known.
You should have been a lawyer. You got yourself a good deal here. What's your name?
Cassandra Floyd.
All right, so you're going to plead to allowing an unlicensed driver to drive and impeding traffic, and they're going to dismiss the no license charge. And they're going to dismiss the speeding charge, and you're going to plead to impeding, and neither one of these are going on your record. Is that what you want to do? If you plead to allowing a licensed driver to drive, possible penalties are up to 500 fines, 90 days jail. So all those. And if you plead to impeding, that's a 0-point civil infraction. Do you understand that? And then I'm going to dismiss the speeding. All right. Did you sign, read, and understand the advice of rights form here today?
Yeah.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yeah.
And do you still wish to waive your right to a lawyer?
Yeah.
To the charge of allowing an unlicensed driver to drive, how do you plead?
I'm sorry.
To the
Not guilty. I'm sorry.
to the charge allowing an unlicensed driver to drive, how do you plead?
Not guilty.
Not guilty? You negotiated with him to plead guilty to this and with the no license to be dismissed, right?
Yes, I'm sorry, sir.
I don't want you to apologize. I want to make sure you understand everything here. Do you understand everything here? Okay,
Yes,
what part don't you understand?
so the speeding and the no licenses being dropped to basically impeding.
And allowing an unlicensed driver to drive.
Right. Yeah, okay, yes, sir, I'm sorry.
And that's not gonna get reported.
Yes.
I want to answer any other questions before we move on.
No other questions.
Okay, I'm gonna ask you again, did the charge allowing unlicensed driver to drive, how do you plead?
Yes.
Were you in control of a 2020 Kia that was being operated on June 23 of 26 on I-75 near Woodruff and Brownstown?
Yes.
And what, at that time, you were operating the vehicle
Yeah,
and you were suspended, or you didn't have a valid license, correct?
my license is restricted. I have driving privileges.
Your license in Michigan's been canceled.
Well, I live in the state of Ohio. I haven't lived in the state of Michigan the last,
You did not have a valid license to operate a motor vehicle in the state of Michigan. Is that true or false?
sure,
Are you on probation or parole?
No.
Anybody force you to plead guilty? Please accept it to the charge impeding traffic, responsible or not responsible.
responsible.
I'll accept that plea, accept the plea to allow an unlicensed driver to drive, dismiss the speed, dismiss the no license. Why aren't you getting a valid license in these places here, man? You don't have a valid license here, you don't, it sounds like you don't have one in Ohio. You gotta have a valid license before you can drive. You probably drove here too, didn't you?
Sir,
Didn't you?
yes, I did.
Why you drove, what are you doing? You come to court for operating a vehicle without a license and you drive, wait a little bit. I wasn't done talking. You're in court for driving without a license, a valid license, and you drive to court? I shouldn't have asked you that. I don't want you to admit that again. But you can't drive to court to contest or to address a driving without a license and then drive to court without a valid license. Now, ma'am, I don't want to hear any excuses. Can't do that. Can't do that. So I'm going to strongly suggest that you call a mother, sister, brother, husband, boyfriend, friend, whoever, to come and pick you up. Because you're not driving out of this parking lot. Do you understand what I'm telling you?
No,
Do you understand?
sir, because I have driving privileges, I have paperwork that say I'm allowed to drive on certain days and certain times.
That's in Ohio, maybe. You have a canceled license in Michigan.
Well, I go
Ma'am,
to school in
ma'am,
Michigan.
Ma'am. I really don't want to argue with you. You don't have a valid license and you're not driving out of the parking lot. If you're so sure you do, then he'll call the police when you drive out of here and they'll decide whether or not they think you have a valid license. But somebody here back on June the 23rd thought you didn't have a valid license. Your record indicates you don't have a valid license. I'm cautioning you. Do not drive out of this parking lot. I don't want to be tough about this, but you can't drive to court on a no license case.
Go back and talk to the court, man, because I'm confused. I'm so confused.
You can trust me, you don't have a valid license. Okay?
To school, even though my school is in Michigan, I live in Ohio.
No,
Okay, okay, I need to go back to the Toledo court then and speak with them.
you have a canceled license in the state of Michigan. You cannot drive. If you thought you had a valid license, why are you in here pleading guilty to anything? Right? Do not drive out of here. If you drive out of here, you're going to get a ticket. And they're going to bring you back in front of me today. Then you're not going to like what I'm going to do. Okay?
Yes, sir.
All right. See how easy I am to get along with. But you cannot drive without a license. All right? We got each other?
Yes,
Go get a valid license. What else do you want to say? Anything?
no, sir.
All right. Where do you work at?
I work at UTMC hospital. I'm in school for nursing.
Good.
I go to Chamberlain University in Troy, Michigan, and I stay in Toledo.
Nurses know to but not violate laws, right?
Yes, sir.
$100 fines, 175 costs, 75 victims' rights, $50 justice assessment, 400 or 90 days, and 175 on the impeding. So you owe $575. Can you pay all that?
Yes,
You're gonna call somebody, right?
yes.
John, you call down there and tell Will to watch him or Brad, and if they see her walk out and you get in a car and drive it, they can call the police.
Okay.
Good luck.
Question, so that one person, Cassandra Forge, if I have like a seat in the, I don't wanna like, I don't know if I can sit there and talk about this without her being there, so I can.
Where's Cassandra Floyd?
She's in the room, her, just so she can kind of listen to the same thing,
Is she the defendant?
yeah, but she's on a ticket, so she didn't have an attorney doing the ticket.
Well, let's just call
We
the.
don't wanna.
We already did her case.
Yeah.
Yeah, but she's just a little confused and I
You
kind of.
told her she couldn't leave the parking lot.
That one?
Yeah.
She says that she has like
Listen,
privileges to drive in school on the paper and she should.
listen,
Perform her school's in Michigan.
I don't want to talk about it. She pled, she was in violation here. She can walk down to the Secretary of State and figure it out. I'm not gonna be,
I just wanna make sure, cause it says on the form that she can drive to school, but she goes to school in.
that's in Ohio. And she's canceled, her license is canceled in Michigan. Look at the Michigan traffic record. It says
I saw
canceled.
that, but if it says that she can drive in school, I guess, yeah, but then her school's in Michigan, so wouldn't they have?
She doesn't have a valid license in Michigan is the point.
Okay, I'll tell her to just go to the Secretary of State.
She can walk right down the street here. Wachowski. Where's Wachowski? Jacob Allen Wachowski, 25W700782. Is this somebody, one of these lawyers? Is this one of yours, gentlemen? Or not?
He's proper.
Why don't you
No,
have a
Judge.
seat right at the table there? People against Jacob Allen Wachowski, 25W700782FY. Come on up here. Your name?
Jake Crosby.
You've been drinking today, huh?
That was not today.
You didn't violate any bond, you didn't violate any sentence probationary terms and conditions, but I don't want you to, we're gonna give you a PBT, okay?
I'm not sure what it is.
Machine you're gonna go blow into. I'm gonna find out if you've been drinking or not. Okay, you didn't drive here, right? You didn't drive here, right? Who drove you here?
Friend of mine.
Where's your friend?
She had already left.
And already leave. That's always what I get. They drop you off and leave. John, have them administer the PBT and we'll see what else they do. Okay, thank you. All right. Jacob Allen Wachowski, have a good day.
Thank you, Judge.
25W700782. Can you come up here with Mr. Wachowski?
Yes, sir, Josh.
If you want time to talk to him, you can. Your name?
John Graziani, appearing on behalf of Jacob Witkowski.
Your name?
Jake Bukowski.
It looks like he posted a bond for failure to pay fines and costs, right?
I did.
The problem is,
Not under my,
I'm sorry,
it's not under my name, no.
he smelled about it. He told me he wasn't true. He said he drank less. We gave him a PBT. He's got a .16. I don't know how he got here. I hear this old adage all the time that I got dropped off. So I don't feel comfortable with him leaving here.
Josh, I do want to indicate though, in my brief discussions, with him, he does not have transportation. He's basically, living paycheck to paycheck, if you want to even say that. He's basically a homeless person who's able to find housing, and I certainly doubt that he has the means for transportation, so I believe that story.
Well, that might be, but I gotta send him to jail. I'm gonna give him a personal bond. I'll let you tell me why I shouldn't. Listen, just let me finish. Just let me finish. I don't feel comfortable with sending somebody out that I don't know has a ride. He's got a .16. So what I'm gonna do, and I'll let you go talk to him if you want. I'll let you argue if you want. But my intention is to give him a personal bond and keep him in jail until his BAC is .02 or less. If you want to go out and talk to him,
May I
that,
speak with him, then, Judge?
yeah,
So you
absolutely.
want it right over here in the hallway?
You just, yeah, whatever.
Okay, Josh, we'll be back.
You're not gonna leave or you're gonna have a big problem.
Oh, no, Josh, I can assure you, he's not going to leave.
Good, good. Wachowski, Jacob Allen Wachowski, 25W7007.
Good morning, Judge.
8-2.
John Graziani, appearing on behalf of Jacob Bukowski to my, please identify yourself, sir.
Jake Bukowski, you're on.
I gotta go back and check on this. It says on July 20, the third party called and wants bond returned to her. Is there anything you want to say? That's my intention.
Judge, he did drink and, that's fine. Again, he'll be let out once it's 0.02, correct?
Correct.
Judge, no problem with that.
All right, I'm gonna go ahead and give you a personal bond, Lisa. Of course, you didn't show up on the other one.
Judge, in all fairness, he has declared many warrants,
No, I get it, but I'm trying to figure out, I've got a $350 bond that I'm not releasing, so I want you to keep this. Just make a note, he posted the 3,500 10% bond. And then you're gonna have to put on the minimus defendant not to be released, until BAC 0.02 or less. So that should be in about 9 hours. 10 hours. So that's what we'll do, and I'm gonna reschedule this for next week, sir. Reset probation violation hearing for August the 4th at 8:30, okay? Is that all right, Lisa? I know I'm piling things on, but I'm gonna be
Yeah.
gone then.
Can we
So
do a
we'll
little
make-
bit later?
You tell me what time.
10:30.
10:30. Okay, so we'll give you a notice for that. August 4th at 10:30. We're gonna send the minimus over and not to be released until BAC 0.02 or less, okay?
thank you, Judge.
Thank you. Is
There you
Derry,
want in the box, what do you want?
is Derry Man here? Yeah, he's gonna have to go in the box. Derry Alonzo Emilio Man, 26B 712-364. Mr. Hussein, you have to take your hat off, sir. All right, good morning, Ms. Ford. Your name?
Good morning, Your Honor. Deborah Geraldine Bledsoe Ford on behalf of Dairy Man.
Mr. Mann, your name?
Dairy Man.
We've had 3 lawyers on this case, it looks like. I hope this is the last one, right, Ms. Ford?
Yes, Your Honor.
I'm a little concerned. I'm not gonna be here the week of the 7th. I'll do a PCC next week. Sir, remember when I told you you had the right to a probable cause conference within 14 days
Yes,
of the
sir.
date of the arraignment?
Yes, sir.
Your lawyer needs an adjournment now. You just retained her, correct?
Yes, sir.
So if I adjourn it again, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes, sir.
You waive that right. You waive that right?
Do you agree?
Yes, sir. Yes, sir.
Could you not hear me, or do you have a question about waiving that right?
Yeah, I have a question to Ms. Ford.
Well, I don't want you to talk to your lawyer about legal advice in front of me. If you don't want me to adjourn it, I won't adjourn it. I'll be glad to go with the exam next week. That's fine with me.
I will not be prepared to go with the exam 110 pieces of new evidence by next week.
Fine, I got it. But your client, he's either gonna waive the right or we're gonna do something else. I mean, I can't make him waive his right.
I waive.
Are you sure?
Yes.
Anybody force you to do that?
No, sir.
All right, so counsel, I'll adjourn the PCC to the 26th. I'm sorry, the 23rd. We can do this at 8:30, right, Lisa?
Yes, 8:30.
Well, I can't do the exam until the 14th. If it says that the OIC is out of town on the 30th, so the prosecutor doesn't want me to set it then, I'm not here the 7th, so we'll have to make it the 14th. Are you available that day, Ms. Ford? Tell
Yes,
me
Your Honor.
yes. Good. July 14th. I'll do that for you. And we'll have it July the 14th at what time, Lisa? 10?
10:30.
10:30. Okay?
Thank you.
So we're
Thank
gonna do
you.
the exam next, or the PCC next week at 8:30. On July 14th, Mr. Mann, you have to show up in person. You understand that, correct?
Yes, sir.
All right. We'll see you guys then. Anything else, Ms. Ford?
No, Your Honor, thank you.
Thank you. Bond is continued. Gary Alonzo Emmanuel Mann, 26B 712-364. Come on up here, sir. Your name?
Gary Alonzo Emmanuel Mann.
Debbie Joe, let's report on behalf of Mr. Mann.
Your name?
Good morning, Your Honor. The people.
Your lawyer and the prosecutor came in and talked to me, Mr. Mann. She wishes to make a motion to withdraw as your lawyer. So I'm going to listen to her. This case has been going on a long time. Initially, I think you had Mr. Upshaw represent you at the arraignment. Then you had a court-appointed lawyer, Ms. Tucker Davis. Now Ms. Bledsoe Ford has been in here. And the case has been going on for a long time for my taste. Go ahead and proceed with your motion.
Yes, it's a motion withdrawal. I literally until yesterday was gonna just man up, go through the nutmeg, but man, yes. But I was deceived with, I can't work under a tight timeline where if I didn't call at the exact second I said I was, then somehow I should feel responsible if this matter doesn't go the way my client desires. I was ready on discovery, reading the discovery about a week ago, and texted him accordingly, and could have met him to meet again after I read it. But he just wanted me to read everything he sent me before I had a chance to read all the discovery. So at that point, I was bad because I didn't read everything in my mind, anyway, at his command. When he told me to do so, I was man enough to do all that. That's fine. But once I'm told yesterday, this text you said that, you didn't do it. This text you said this, you didn't do it. My mom is here, she's a witness, she's listening, you didn't do it. On and on, I'm going to be texted what I've never even heard of before. There are discrepancies in this discovery with some of the things he's telling me. I believe it would end up being questioned. In fact, I don't think, get this dismissed. And for multiple reasons, there are multiple reasons, there are multiple phone records, there are multiple videos, there are multiple pictures that support the entries. I was told to get a record of the entries because they didn't happen until he got the discovery, which he says he didn't get all of it, but I believe he sent it all. It shows she sent them billing. I mean, I can't make this happen. I do not feel I can be as zealous as my personal standards are, and it's effective. I have personal standards.
Okay. So you're just telling me there's been a breakdown in the attorney-client
Yes.
relationship.
Yes.
You don't have anything.
Office money. He gave me $2,000. I can give it back. In spite of all this work I did.
Not yet. You don't have any objection or anything to add, correct?
Your Honor, I agree with your expression.
Listen, if there's been a breakdown in the attorney-client relationship, I don't need you to tell me why she's doing a good job or a bad job, or should be your lawyer or shouldn't be your lawyer. If you have an objection to her withdrawing, then you can feel free to voice that. Otherwise, I'm going to grant her motion. But I'm having concerns here that at some point I have to clear this case off the docket. It's a serious charge as far as I'm concerned.
Judge, I do.
Hang on. Yeah, are they here?
They did all show, Your Honor.
We'll bring them all in. And I'm going to let you talk. Go ahead. I don't want you to say anything to incriminate yourself or anything else, but you've gone through 3 lawyers now.
Yes, sir. I'm sorry about that. I was trying to proceed the process with Ms.
What law school did you go to?
Excuse me, sir.
What law school did you go to?
I didn't go to any law
Did you
school.
graduate college?
Yes, I graduated high school.
All right, but you didn't graduate college. I'm just telling you, sometimes we tell lawyers things that we have no business telling them because they know like a lot more about this than we do.
Yes, sir.
You know what I'm saying? We wouldn't start criticizing our doctor and telling our doctor what to do. If he tells us we've got a serious illness.
Yes, sir. I wasn't criticizing you, sir. I just didn't get none of the proper material that I needed. I didn't receive my discovery, my second part of my discovery.
All right, listen.
We have proof.
Hang on.
Disprove it.
Hang on.
I got to say,
Hang on. Hang on. I don't want to be interrupted. Do we both agree here that there's been a breakdown in the attorney-client privilege, the attorney-client relationship? Could you agree with that? Do you want her to leave the case or be on it?
I wanted to, I said, yes, it's a breakdown. I wanted her to proceed. When we got here today, she switched it up on me.
After last night, I slept on it, I just realized I've set myself up for all kinds of bullets.
Okay. I'm gonna grant the motion to withdraw. Where are the witnesses at here? Why don't you guys all come on up here? Come on up here to the podium. You are free to go. I want your order by the end of the day or an order allowing withdrawal, okay?
Yes, sir.
Put them up on our speaker.
Yeah.
You stay right where you are. Yeah,
Well, I said I would return this 2,000 by Friday. Okay.
that's up to you guys. I'm not getting in the middle of your dispute here. There's no lawsuit in front of me. You're free to go. I know. I got it.
Thank you.
Okay. I don't mean for you guys to sit. I certainly don't mean to inconvenience you. I'm sorry you were brought in here. This case's been going on for the longest time, and I'm not going to let it go on much longer. Now, I have to make sure this young man's afforded a new lawyer, or we're going to provide you with one at public expense. But if you're going to hire a lawyer, you better do it in the next 2 or 3 days. I'm setting dates on this case that I'm going to stick with. You will be able to provide them with all of the discovery. Your lawyer will have all the discovery to give your new lawyer. So Lisa, let's first of all set this for July the 28th for a PCC. And you give me the time, please.
9 o'clock.
At 9 o'clock. And then the preliminary exam, which I'm not going to adjourn again. August the 4th at
11 o'clock.
So I'll go on this report, and it's going to look like I was fooling around with this case, and that's nothing further from the truth. What is your name, ma'am? Ma'am? What is Elizabeth what? And what is your name? Yeah.
Vicky does.
What is your name? What is your name? And what is your name? I'm sorry?
Eric.
Folks, I'm going to ask you all to return here. This isn't right that you were brought in. And these things happen. They don't make me happy. This should have been handled before. And I'm not at all happy about the fact that on the date of the preliminary exam that's been scheduled for quite some time with multiple adjournments, that people are coming in here and telling me they don't want this lawyer and I don't want to be his lawyer and that kind of thing. But I'm going to expect you to come back here for the preliminary exam on August the 4th at 11 a.m. I'm going to expect you to stay in touch with the prosecutor. This is a serious case, one way or the other. If he didn't do it, I want him found not guilty. I want to dismiss the case at that time. If he did, there's another process. But I want you to stay in touch with the prosecutor, and I'm going to ask you to confer with her and make sure that you're here on August the 4th at 11, unless she tells you there was a waiver or some other disposition. That's the only thing. But I'm more calling you equally as much to apologize that this happened at the 11th hour when it shouldn't have happened at the 11th hour. I mean, this case has been going on he was arraigned on May 29th. I'm supposed to have these done in 28 days, so it looks like I've been fooling around, and that's the least furthest thing from the truth. But I want to thank you guys. I want to apologize to you. System broke down a little bit, but it wasn't our fault. Have a nice day. Thank you very much. Stay cool out there. Good luck, sir. You're going to go down and get your notice. I'm telling you, July 28th, you said at 9 o'clock and in August the 4th at 11, right, Lisa? And I want you here in person on July the 28th. Do you understand me?
Yes, sir.
We'll get him a lawyer as soon as we can. Lisa, thank you very much. Thanks, Sergeant.
No problem, sir.
Derry Alonzo Emmanuel Mann, 26B7123645. All right. Good morning, Ms. Fanning. How are you?
Wonderful, Your Honor. How are you?
Good. Your name?
Attorney Andrew Fanny appearing on behalf of Mr. Mann. Your Honor, I've not had an opportunity to speak to Mr. Mann. I was just appointed, so I probably need a breakout room with him first.
I don't even see him here. Is he here, Lisa?
He is not on Zoom.
He's not here.
Okay,
So I'm
so we'll
gonna
pass
have to-
that one. And I don't have a contact telephone number for him or anything.
How come this case is still going on? My Lord. It's from May.
Judge, this is the one where he's been through multiple attorneys. I think Miss Fanning is the fourth.
I don't remember all of these. Why? What? He
He's-
keeps firing them? He's gonna do this himself or what?
Yeah, his original attorney was for arraignment only. Then we appointed an attorney. Then he hired Miss Ford. But last week she requested to be removed, and now Miss Fanning's been appointed.
Well, you better try to get a hold of him. Do you have his number?
I don't have a number for him. Can you give that to me, please?
Lisa, can you figure out?
I
here?
do not have a number in the system here.
Yeah, the information that they gave me did not contain a number. It just contained an address. And again, I got it late yesterday. So with that being said, I will do my best. I understand that it's scheduled for exam, the prosecutor for next week. I will be present. I don't know if he'll be present, but I will be present there on next, on the
Issue a
4th.
warrant for his arrest if he doesn't show up today, and it's gonna be a high
Understood.
bond. And then we're gonna show cause Lisa, the surety company. We're gonna show cause them and let them worry about it. This is 100,000, 10% bond that was set back on May the 29th. And I set it. Oh, this is the one. I remember this one.
I'm just double checking to make sure he's not in custody.
He
Yeah, I don't
can't
see
be.
anything.
I mean, he can't be because he posted the bond.
Well, I thought maybe he had new charges somewhere, but I don't see anything.
Well, Your Honor, I would just ask if we can continue it to the exam date.
I'm not gonna make them
Okay.
bring in witnesses when your client he's been firing lawyers left and right. I mean, I guess he knows more than lawyers, and now here's the fourth lawyer and he decides not to show up. I'll wait a little bit for him. I'm gonna call
You too, buddy.
Mr. Derry Mann here. Derry Alonzo Emmanuel Mann, 26B7123664. Ms. Fanning, your name?
Thank you, Your Honor. If it pleases the court, Attorney Andrew Fanning, P42853. I'm appearing on behalf of Mr. Mann. Your Honor,
Go ahead.
I just was gonna say, just for the record, I was just appointed late last night. I do not have a telephone contact number for my client. It's my understanding that this matter was put over from last week. I cannot explain my client's non-appearance here today.
Ken, I think this is a willful intent to delay adjudication, and I've kind of had it with him. I don't know how many different lawyers he has. If he went to law school and he thinks every lawyer is stupid or what have you, but you're his fourth lawyer. This is a willful intent to delay adjudication. I'm issuing a warrant for his arrest. We're forfeiting the bond. I want to make sure you issue a show cause against the surety company, Lisa. Issue a show cause against the surety company as to why the bond shouldn't be forfeited for defendant's failure to appear. In the meantime, I'm setting 250,000, 10%. If
Thank
he's
you, Your Honor.
cavalier enough to forfeit 100,000, 10%. That's
Thank
it.
you.
Sorry, Ms. Fanning. Have a great day.
All right, we're back for our afternoon docket. This is the even numbered Tuesdays, and on those days I get the preliminary examinations. We had 4 scheduled for today, actually 5. One was adjourned, one was a waiver, one was misscheduled, and will have to be reset. And that leaves 2. I'm going to address one of those now. Good afternoon, Mr. Duchatelier.
Good afternoon, sir.
This is Judge Middleton. We've met both live and Zoom wise, but you're set for a preliminary examination this afternoon in file number 261271. Your attorney in that case is Jordan Harden, and she's here with you. Also present is prosecuting attorney Deborah Davis. In that complaint, it is alleged that on July 4th, you did possess methamphetamine. That in and of itself is a felony punishable by up to 10 years imprisonment and a fine of up to $15,000. You're alleged to be a second or subsequent offender, which doubles it to 20 years. And you're alleged to be a fourth habitual offender, which theoretically would make it punishable by up to life or any term of years. You have a new charge in file 261416, which is very similar to this one. It's another possession of methamphetamine charge from July 24th, and I'm going to arraign you on that one in a minute. And there may be another charge, some sort of a larceny charge that's under review right now from the prosecutor's office, involves a theft of a hoverboard. I'm not clear on the facts, but that has not yet been authorized, and I won't be arraigning you on that, but I'm putting you on notice that that might be forthcoming. Anyway, today's case is set for preliminary examination today. The witnesses are here. Prosecutor Davis is here. She's ready to proceed. But I understand at this point, Ms. Harden, we're going to have a waiver of the examination.
Yes, Your Honor, in light of the charges that Mr. Duchatelier is about to be arraigned on, as well as the representation that waiver in an attempt to resolve this at the circuit court, that the prosecuting attorney would not pursue the pending larceny charge. He is ready to execute that waiver on the record.
Is that correct, Ms. Davis?
Just clarifying, we won't be authorizing it at this time, and so long as the case is resolved with a global offer, it won't be authorized ever. If everything falls apart, we would reserve the right to.
I apologize. I can barely hear. I was assaulted prior to being locked up, and my eardrum is blown.
Would you like to use the headphones?
Yes, please. I could barely hear out of this ear.
Why don't we set them up with the headphones? Something bad is happening outside. The deep horns are the fire trucks. Is that better?
Yes, sir.
All right, thank you. I'm not sure how much you heard of what I said. Our understanding was that you're going to waive preliminary examination in the July 4th incident, 261271. I'm going to arraign you on a new charge, July 24th incident, file 261416. Ms. Davis mentioned the term global resolution. That means they're going to try to work out all of your charges, the ones that are bound over, the ones that are new, the July 4th one, the July 24th one, perhaps that larceny charge that I mentioned, see if they can resolve everything all at once. So I understand this waiver is in pursuit of perhaps a resolution of all your charges. Do you understand that?
Correct.
All right, well, let me read you what the waiver of examination says. I, Mark David Duchatelier, say I have a right to employ an attorney I may request a court-appointed attorney if I'm financially unable to employ one. Ms. Harden is here to represent you. I voluntarily waive my right to a preliminary examination where I understand I will be bound over to the circuit court on the charges in the complaint and warrant. So here is that waiver. I'm going to ask you to execute that. Have Ms. Harden sign it. I'll have Ms. Davis sign it.
That one was for the,
It's for the July 4th.
What is
not
it,
the new
Brandon?
one. Yes. Yep, and then I'll give you Raymond on the new charge and I'll ask about that. Okay.
Bring it
I
on.
don't wish to wait my payment.
You don't want to waive your
For
feeling
you,
now?
Brandon.
Wait,
Thank you.
it's to wait for the,
You don't want my pen?
Ms. Davis, why don't you keep that and have it executed?
Sure, I'll take it down.
Your
to
staff
them.
would always be mad at me when I would take those and they didn't get a copy of them. So once you're done with it, forward it to the court and I'll sign it. Bond in that case is set in the amount of $8,500 and it will remain at that. Sir, how do you say your name? You and I have talked about this before, and I'm not sure I'm saying it correctly. How do you say it?
Mark Duchatelia.
Duchatier. All right, I'm in the right neighborhood. You say it better than I do, but Duchatier. All right, sir, you got a new charge. Excuse me, I'm losing my voice. The new charge is 261416FY. In that case, it alleged that on July 24th, you did possess methamphetamine, again, as a second or subsequent offense, making it a 20-year maximum felony offense as a fourth habitual offender.
I beg your pardon?
What?
Can you repeat
As a
that?
fourth habitual offender. So it's essentially the same charge you're charged with now, just a newer date. Because that is a felony, I have to set it for a pre-exam conference and a preliminary examination. Excuse me. I'm going to appoint an attorney. The most sense is to appoint your current attorney, but I'm not sure what the system calls for. We'll set a pre-exam conference. I don't know who stole my calendar, but it appeared. Set pre-exam conference for August 11th. At 8:30, excuse me. Preliminary examination if needed for August 18th at 1 o'clock.
We would ask to be heard on bond, Your Honor.
Yes, now let's talk about this. I have to set a bond in this matter. Before we get to the dollar amount, let's just talk about the conditions. How come I didn't get one of those when Josh left? It is ordered that you shall post a new bond and comply with the terms personally appear for any examination, arraignment, or hearing, including the sentencing, as scheduled.
Excuse me, Your Honor.
Yes?
If given a PR bond with the stipulations of a monitoring device, that way I can be able to go to attend my pivotal and get my
All right, well, we'll get to that. We'll get to that in
proper
a minute.
medical attention that I need, and also so I can go ahead and go into my I was getting ready to attend to it's in Kalamazoo. It's a recovery center. And so if you give me the PR bond, I can finish going to get my Medicaid and everything through Pivotal and everything, and I'll be able to go to attend my
Mr. Duchatelier, I'm not gonna give you a PR bond. I didn't just fall off the turnip truck. Since you got, stop. Since you got here to St. Joe County, you have not been an asset to our community. You and I had this same discussion right after those consecutive larceny of building charges. In file 251935, you were charged with larceny of building from August 8th of 2025, and that matter was bound over to circuit court. On October 15th of 2025, you were charged with a separate larceny of building in file 252138FY. That matter was bound over to the circuit court. I believe it's resolved. Then you were charged with assault with a dangerous weapon and felony firearm in file 252391. Not sure what the status of that one is. It was dismissed, maybe as part of the other case. Then, in 2026, you're charged with resisting, obstructing a police officer. And
I was charged with what?
You were charged with resisting, obstructing a police officer. That was also dismissed. Then you were charged with trespass and illegal entry in file 26359SM. That was in March. In that case, I gave you, or Judge Pattison gave you 30 days jail for that offense. That was in March 9. You have a pretrial in a new case, disorderly person trespass, June 13th. But not guilty, that's pending. Then you have this charge from July 4th. The new charge from July 24th. Since you got here a year ago, you've been charged with 6 felonies and 2 misdemeanors in 11 months. You've got a substance abuse issue, I agree, and you've also got a mental health issue, which you're trying to address. But the solution to that problem is not a PR bond, where you're out floating in the wind with a methamphetamine addiction and not adhering to your mental health.
No, that's why I was saying with the stipulation. That's why I was saying with the stipulation of with like a ankle monitor or something.
No, this is for your own safety and public safety. You're just gonna, if I just will let you walk out of here tonight, you'd be in the
No, it
same boat.
wouldn't be to just let me walk out.
All right, well, don't worry about it, because you're not getting a PR bond or a tether. But here are your conditions. You're not to leave the state of Michigan without permission of the court. You're not to commit any crime if you do post a bond. You're to provide email and telephone number to the court and immediately notify the court of any change of address. Do not use or possess alcohol or a controlled substance unless prescribed by a doctor. Now, to tell you to say, don't use methamphetamine is like saying, hold your breath till I see you again. It's hard to do. We need to get you in a situation where you can process. Do not possess or purchase a firearm or any other dangerous weapon. Do not assault, harass, intimidate, beat, molest, or wound any other individual. Comply with all mental health orders. I'm going to set the bond, and then the previous bond, July 4th bond.
He did post that bond, Your Honor, and appear for court. I believe he does appear for his hearings. It's not, he's a flight risk.
He has generally, he's missed some of those early hearings. In the Larson building case.
I know Mr. Gabriel and I were talking, it's not clear from the ROA if he is still on circuit court probation or not. He tells me he's not on circuit court probation, so there's that aspect to consider as well.
Well, those two felonies were just bound over in 2026. I wasn't clear.
He was sentenced in February of this year on those, and it does show an order of 12 months probation. It looks like there was a potential hearing on a probation violation in May, but I don't have any notes that show if that was revoked or not. So he is under that supervision as well. I would ask the court to consider that when setting bond. If that probation still remains in place, like I said, unfortunately, I cannot tell from the ROA if that's still an active probation order or not.
I want to set bond. This is essentially just a possession case that's doubled and supplemented. But in light of everything else that I just stated on the record and the fact that he's on circuit court probation, the bond is set in the amount of $25,000 cash or surety. The matter will be set for status conference in the bind over, and this matter will be set for a pre-exam conference on August 11th. The bond could be revisited at that time if there's some sort of a plan about doing treatment or something. Right now, it's all sort of nebulous. But right now, you need to be right where you are until everything settles out. See what's going on with these new charges with 2 felony probations and some other cases bound over. All right. So you're good to go. The bond is $25,000 cash and surety, and the conditions are as I stated.
And how much is that?
25,000.
So 2,500?
If his bondsman, I would have to talk to them. It's a cash surety. That's my assumption.
So is that in addition to the 15?
You didn't have your bond revoked in the other case. Yeah, you have to post an additional bond for the same charge.
So the one that I already had posted, is it revoked?
Not that I know of.
So I have to.
And Your Honor, just for clarification, the underlying charge in which I represent, and his bond is still valid. He's posted bond in that file. That bond's not valid.
I didn't revoke that
Okay,
bond.
okay.
If that's the case, I don't know where my prelims, we could go right now.
Deborah, can you tell anything about his probation in circuit court?
If that's the case, I don't want to with my prelims, we could go ahead and go for it.
Your Honor, he now indicates he wants his prelim.
Thank you.
I guess I'm
Too late.
I'm
I've
confused.
accepted your waiver. You can go to court at your pre-exam on
If I had to sit with a $2,500 bond.
11th of August. I'm not going to be bullied by you waiving a
You were not
prelim.
told, you
And
were
you
not
don't
told.
like my bond, so you ask for a prelim. You
You
waived the prelim. I've accepted your waiver.
I advised him that,
I was
wait,
under the impression of that if I were to waive my prelims, then I would have the ability, the possibility for potential, PR bond.
I told you I wasn't gonna give you a PR bond.
We did discuss.
If you keep dancing around, I'm gonna cancel your earlier bond. You go with the court officers. You waive the prelim. You're not gonna tap dance with me and waive it and then say, I didn't get a PR bond. I told you weren't getting a PR bond. You can go with the court officers. You guys can make further record on it August 11th.
This has already been waived. It's already been waived. Waive it? I'm not sure how we would do that. We'd have to file something.
You want to take that one down? You don't have a copy of that.
It's already,
No.
the judge has already said no.
Judge, do you have a
Nobody forced you to
copy
waive
of
it,
the Brumfield waiver that? we can
I do.
Get that, please.
Good morning, Mr. Grimes, or good afternoon. I don't really see you much. See you on TV sometimes.
Yeah, do you want to make a quick record?
Sure. Good afternoon, Mr. Brumfield. What?
I just wanted to place on the record as regards to Mr. Duchatellier, when I was discussing the waiver with him back in lockup, he did indicate he would waive if he was guaranteed a PR bond from Mr. Gabry. I spoke to Mr. Gabry, he indicated that was not something he was comfortable doing. I relayed that to Mr. Duchatellier in front of the deputy, indicating that there was no promises to a bond or a PR bond at this time, but the argument could be made for that PR bond, so.
And I told him I wasn't gonna give him a PR bond, but yes,
So,
what you just stated on the record comports with my recollection of the discussion that was here.
I just wanted the record to be clear, there was no promise
I'm
of
gonna
a
actually
PR
do
bond
an
or
order.
a waiver.
Denying his request to withdraw his waiver. So there'll be something in writing.
And he did ask that again as he was being let out, that he was demanding his prelim in the case that he just signed the waiver on. So.
All right, I'll do it.
Just to be clear for the record, Your Honor.
All right, thank you.
Court does call the case, People versus Travis Higgins.
Both people.
Why is Sizemore not sitting?
No, it's okay. Good morning, Your Honor. David Shan, on behalf of Travis Higgins. Travis, can you state your name for the record?
Travis Higgins. Thank you.
Your Honor, we are going to waive preliminary examination.
Right. Sir, is that correct? Yeah. You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. Yes, sir. You understand you'll not have that hearing, but you'll proceed to circuit court for further resolution. Yes, sir. People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendant is bound over to circuit court on count one with two following.
We'll stand mute, Your Honor. Waive formal reading of the charges.
Defendant have waived formal reading, standing mute to both counts. Court will enter a not guilty plea. Pretrial will be set for
August 10th at 1:30 for Judge Moore.
August 10th, you said?
Yes.
August 10th, 2026, 1:30, Judge Hamud.
Can I address bond, Your Honor?
Why not? Everybody else. Go ahead.
You remember, he couldn't stop using and we had to get him someplace safe. He went in the hospital to detox and he was there for a week. As soon as he got out of the hospital, you had told him to report to the jail immediately, which he did on the 15th of July. And he reported right from the hospital to jail. He's been there ever since the 15th. I just got notice this morning that he is eligible for felony treatment court. They would like to do a screening and assessment as soon as possible. So I'm hoping that I can get him released back to his father's house and to get him continue in recovery. He's done everything that the court wanted him to do, obviously in a scram tether with testing requirements, but I think it's a really good what you did here to allow him to safely detox because he has seizures and he's been injured before from the seizures. So when he was in the hospital, he went through the seizure protocol and got through that. And he's been in the jail now since I'm hoping that you allow him to go back home and we can get him into felony treatment court.
Your response to the people.
Yeah, I still have a lot of the concerns I had the last time. I just want to place on the record. This is an OWI third. The priors are from 2016 and 2024. in this case, the alleged offense is that he was operating under the influence of fentanyl, methamphetamine, and THC. He did have some very concerning initial positive tests. More concerning, maybe even so, is that he stopped showing up to community corrections, and then the warrants got issued and everything that Mr. Shan just placed on the record happened. I'm very optimistic about felony treatment court for this defendant, but the concerns I have for bond right now are just the not showing up, kind of going up. I'm just worried about his ability to keep the public safe and how much the public safety does depend on that at this point, but I leave it to the court's discretion.
When is his assessment?
Courtney said as soon as tomorrow that
He may do that tomorrow.
tomorrow, yes.
Okay.
Now that I'm clean, I have full intention of showing up to community corrections. I just kind of,
You know what? Hey, young man, I'm not mad at you. Okay. I'm mad at the drug that you're hooked on.
I saw him yesterday. I said, I've known him for a long time. This is the best he's looked in a long time.
I remember when you were.
I'm on the MET program now, and I don't know, I'm giving it my best effort.
Yeah, no, I got you. So, who would have his felony?
It would probably be Judge Carol Cookie, because she's doing most of the felony. This is a felony drunk driving. However, his drugs of choice are all are non-alcohol related.
Okay.
So it's meth and Xanax, methamphetamine. Well, it's easier to list the drugs that he's not taking than it is the drugs that he is taking. So I think he'd be a perfect fit for Judge Cookie's felony treatment court. And I've already let Judge Hamoud's staff know that he's coming. So hopefully we'll have everything lined up for a smooth process and get him in treatment court as possible.
Okay. Here's what I'm going to do. And understand, I'm not doing this to punish you, young man. I'm worried about you. Okay. And I think you have full intentions of doing what I say, but I'm just worried about it. I'm going to deny the request for a change of bond at this time. However, I'm specifically placing on the order that I have no objection to his release after he's assessed by drug court.
Perfect.
All right.
Perfect. That's all I was. Thank you, Your Honor.
At this time, his bond will continue. All right. Thank you. Good luck, Chief.
I'll let Courtney know she'll probably be here.
Did you know the number for him? No? You guys are doing me no good. Court does call the case. People versus Matthew Moy. Your name?
Name, sir?
Oh, Matthew Thomas Moy.
Good morning, Your Honor. Marcia Page on behalf of Mr. Moy. Your Honor, we have two asks today. First is to adjourn the PCC for obtain discovery and further plea negotiations. And the second ask is we would ask the court to entertain a bond reduction motion.
Go ahead.
Okay. My understanding that Mr. Moy has nothing else holding him. He has a current job at Kentucky Fried Chicken. He needs to get back to his job. He also has some apartment that he needs to make sure that the rent is paid. Currently, his bond is $1,000 cash surety. We'll be asking for a personal recognizance bond. This is a resisting obstructing. It's my understanding that there was no injuries to the officer. It was basically a running from the police situation. So we'd ask for a PR bond, Your Honor.
Response.
And my understanding is that the defendant's been on probation in circuit court for carrying concealed weapon and possession of a controlled substance for quite some time. There was violation of probation resolved in May 2026 when he had completed treatment. He also has an assault battery pending while he's on probation. In this case, was pulled over, asked if he could swap away from the traffic stop, but the police officers told him no because he had active warrants. He then ran. So I have no faith that he will come back.
He explains to me that he will come back, Your Honor. Mr. Moy.
Matter of court.
Go ahead.
Your Honor, this was
This incident was about 5 months ago.
I'm gonna ask you not to talk about the incident,
Okay,
so.
I'm just talking, okay, I won't discuss the incident. I was released so I could go to treatment. I've been keeping up with probation. I'm in the courthouse every week, Your Honor. And I've been keeping up with my appointments. The KFC that I work for is right across the street. I've been dealing with the court system for a while, Your Honor, and I understand that I have to take care of these things. I'm not going anywhere. It's not an
Why
apartment.
didn't you come back though?
Why did I come back?
Have all these warrants and then they pull you over, could have dealt with it, but then you took off.
Oh, I didn't take off, Your Honor.
Okay, hold on.
The charges were just filed.
I'm gonna advise you at least.
Yeah, I would.
And not want to say anything.
Yeah, I was.
Fence. Felt as you were gonna say something else.
I want to clarify, they got him, so he ran from the traffic stop and they were able to catch up with him and put handcuffs on him. I'm not sure why there was a delay in the case. But my understanding from the police report is at the time of the arrest, he had active warrants. And that was in February of this year. And since then, there was an assault and battery case in Ypsilanti, which has also been filed with an incident date from April of this year. And now we are here, both of those having happened since he's been on probation for the CCW case, is my understanding.
I'll grant the motion, but I'm not gonna give him a PR. I'll make it a 10%.
Thank you, Your Honor.
Round.
Okay, thank you.
If I have to give you a date, we'll set is for a PCC. PCC will be adjourned to August 6th.
On tether for 4 months. I showed up.
You want to keep talking? You want me to change it back?
No, sir. I apologize. I'm not trying.
I mean, I gave you a break because with all that stuff, I shouldn't do it, but I can't give you a PR.
I understand.
All right, I'm done. Thank you.
I'm not trying to talk back. Beth. Hold up there.
You know,
Your Honor, I'm sorry.
showed up every time. Because when you show up every time, you get warrants. That's how we got 3. What? No, I'm not doing anymore.
Oh,
What do you mean?
I gotta go.
Everything is going just fine. I see ghosts. I didn't hear you.
Okay.
Court does call the case people versus Chelsea Morales.
Haley's done on behalf of the people, Your Honor.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Morales, who's approaching the judge.
State your name for the record. Celso Morales.
Simpson.
Yes, sir. Your Honor, at this time, we'd ask the court to set up him in this manner.
Your Honor, there is a video that it's a video that defendant sent to victims, their shared child of them lipsing the comments, but we do not have that yet, so I'm not sure when we get it on as part of the stalking.
Your Honor, we have explained that to Mr. Morales.
And Mr. Morales doesn't want you to see that before having an exam.
It was described, Your Honor. It said, it was explained to him. It was described in the police report. We have gone over that with him.
And I put a request that was yesterday, I not rejected it, so I.
So Mr. Morales, you understand your defense counsel hasn't seen any of that?
Yes, Your Honor, I do understand that.
And you want to go forward with a preliminary examination?
I wanted to revisit the bond conditions, if that was to my understanding, that we would revisit bond conditions.
Well, they can ask for but they're doing 2 things here.
Yes, sir.
You can certainly ask to have the bond addressed, and I'll take a look at what the deal is with the bond, but want preliminary examination set at this point? without your counsel having all the discovery in front of you and being able to show it to you?
I'm sorry.
That was a question mark.
Yes, Your Honor. I'm sorry. Could you repeat that for me?
Want your preliminary examination set now. So your attorney, my understanding has been told to you, doesn't have the video which is pertinent to the stalking charge, nor the text message that goes along with that video. He hasn't been able to show it to you.
Yes, Your Honor. I thought under the conditions that we would revisit my bond condition right now. I understand what you're saying about the setting the preliminary exam, and I'm not opposed to that because I do not want to hold up the proceedings of the court. I don't want to disrespect the court in any matter.
It's a matter of disrespect. It's a matter of your rights and whether or not you're going to be fully protected. That's all I'm looking at.
Yes, Your Honor. Do you mind if I read this note for you that I prepared?
But no,
I would advise against it. I believe it's about his conditional
The
bond.
conditional release and PR that I wanted to address. Yes, sir. Yes, sir.
when is the video going to be available? Do we know?
Sure, I'm gonna put a request in. It's through Pittsfield and they're normally very responsive, so I would hope next week, but I can't speak for certain that it would be available.
Your Honor, for what it's worth, I believe there was a transcript of the video in the police report.
It was just a description of
What's on it, but haven't seen it.
I have not, Judge, no.
All right.
It was a rap video, is what
I'll set preliminary examination in this matter for August 11th, 2026, 9 a.m. for Judge Garwood.
Thank you, Your Honor. Your Honor, if I could be heard on bond.
Yes.
Your Honor, Mr. Morales is here in court. He does have a rather high bond in this matter. I don't believe he has any holds. He does live locally with his significant other. He can reside there. I can give the court that address. I don't believe it's more than a couple miles away from here. Your Honor,
so the individual stalked is not his significant other?
No, Your Honor.
Okay, go ahead.
Allegedly, Your Honor.
Allegedly stalked.
Your Honor, as I said, he does have a place to go. He is under the care of a therapist. He does take medications. He is a recipient of SSD, so he does have income in this matter. He would avail himself of any kind of GPS tether or any other condition that would allow him to both be free in this matter while he's awaiting his exam, but also protect the public in a way that would satisfy any concerns that the court may have, including a tether or any other kind of restrictions. So we'd ask the court to reduce his bond to a personal recognizance.
Your Honor, I would be objecting. We originally requested a $75,000 cash surety, which I would be requesting at this time. This is a case where Ms. Morales pled to 2 stalkings in 2025 with the same victim in Ward State 2. That was worked out as a part of a resolution before they were originally felony charges of stalking. He then, in this case, was messaging the victim directly and then also messaging their child, their young child's tablet, saying, "Are you with your mother?" Then sending a video to the child's tablet of him lip syncing to musical lyrics, beat her ass and kick her out the way, and finally the opposite, you're going to die with them. Their child's tablet after asking for their child's mother with them, while having his fingers in the shape of a gun. So I am concerned that he should not abide by court, pled to stalking and the domestic violence charge in 2025, and is continuing to harass the victim. I don't think he can abide by court orders, and I would have concerns if you were to be released. So at this point, I'm going to be requesting our original request of $75,000 cash surety. I think that is given this behavior throughout 2025.
Well, Your Honor, look, these are allegations. One thing I didn't hear the prosecutor say, that he's no longer on probation for any of these matters.
But there prior, you said prior domestic violence and stalking?
2 convictions for stalking in 2025, and I have to double check with 482. I didn't see it upload in Excel grams, and I would find it hard to believe that he's not on probation for those anymore. And then he had also that previous conviction for domestic violence with the same victim. Sure, John.
the same victim as in this case. So I'm confused. The significant
The significant other,
now somebody else that he lives with.
whom he resides, yes, is a different person than the complaining witness in this matter.
But I have like the stalking charge and then 2 other stalkings in a DV against this person,
Uh,
right?
can't dispute that. Judge.
Anything else?
Nothing further, Judge.
Defendant's motion for reduction of bond is denied. I will grant the people's motion. I find that the assessment of the bond in this case, it's abuse of discretion, and I'll set the bond at $75,000 cash surety.
Thank you, Judge.
Yeah. Clerk calls the case, people versus Matthew Morrison, aka Esther Murphy.
Chelsea Virgils with and on behalf of Esther Murphy, formerly known as Matthew Morrison.
Esther Murphy.
You're requesting an adjournment?
I am. Ms. Feltus has indicated she'd like to see some compliance on bond prior to making an offer, so we're asking to adjourn for a plea discussion, and I would ask to address bond if Your Honor would allow.
Yes, go ahead, address bond. I'll give you a date.
Your Honor, I'm asking for a personal bond, potentially with a scram tether if the court sees fit. Ms. Murphy is happy to report she has stable housing now. She is staying with her aunt in Ann Arbor. Her aunt is sober, and so is Ms. Murphy, and she would like to stay that way. No prior convictions. She does have some open cases, but those are just orderlies in the 15th District Court, which she hopes to take care of. She has previously gone to AA or NA in the past and wants to work on continuing staying sober and having just an environment of stability. Notably, she is unfortunately in the advanced stages of liver disease, and I would argue that the jail can't provide the level of health care that is necessary for her continued survival. She needs exceptionally clean air, water, and food, have her enzymes tested frequently to make sure that she's not at risk of actual death. She is at this time actually having severe pain and is worried that it could get much worse quickly. She has almost died from liver failure twice in the past, extensive history of stays at the U of M hospital. So in order to get the medical care that she needs and to show that she can have the stability that the prosecution would like to see, I'm asking for a personal bond.
Ms. Murphy did fly with her scram tether for about 2 months earlier this year, and then sort of drops off the face of the earth. So people are willing to give her another chance if the court would allow it, with release on a scram tether with weekly downloads. But should she fail to appear for a download or fail to comply with her bond conditions, we would not agree to any additional releases. Would like to see her fly. I do believe that the officer here is willing to negotiate, is comfortable with misdemeanor, but now it's me that wants to see a little bit of more compliance, and we lost her from March till July, so it'd be nice to just get her back to compliance.
But prior to that, she was complying.
She was on scram tether, I believe, from about the middle of January to the middle of March and compliant. No issues.
Got it. And then what happened?
Your Honor, if I may, Ms. Murphy had housing instability, nowhere to stay, and there was a place available in Lansing for her to stay, which she thought would be a more stable environment and ended up not to be, but she didn't have transportation to get back to Ann Arbor.
That's what I want to know. So after that 2-month period,
There was,
trying to do something else.
yes, she was trying to have stable housing and job and sobriety in Lansing, and she thought that going there, she had the opportunity for that environment. It turned out not to be a good environment, but at that point, she couldn't get herself back here. I think that she would admit to the court that she removed the tether, didn't have it on. However, she did for a long period of time stay sober and is still dedicated to staying sober, partly due to her health, which, as I mentioned, is very essential, but also just to live a better lifestyle.
Came back into custody. How?
I believe she was playing guitar on the street and somebody called in for a wellness check. I don't believe
It
any.
wasn't playing the guitar well, or what? Get. I know that was wrong. Was it? No.
I don't think
If I was playing the guitar, somebody probably.
we may need to consult the body worn camera of that.
Okay.
I think any new charges are expected.
Here's what I'm gonna do. Got an address in Ann Arbor, right? Is that right?
Yes, we can provide that to the court today.
Okay. So what I'm gonna do is I'm going to release her on a personal recognizance with a scram tether. Got to comply with that. Right, and I'm just gonna let you know, especially with the medical that counsel's indicated to me, that if you're not in compliance with that, I figure you don't want to be out and may not want to live. So I'm just gonna take you in and then you'll sit. We understood?
Your Honor.
And then I'll set the date of the August 20th as her next piece.
Thank you.
All right, thank you. You're welcome. Court does call the case, People versus Christian Reed.
Good afternoon, Your Honor. Reed Cook.
People.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Mr. Reed. Good afternoon, Your Honor. Christina Faxon for Mr. Christian Reed on the matter ending in 0422. So, Your Honor, we are both.
Only have one file.
There is only one file. Yeah. Yeah. I need it back up.
Pressing me.
There is, oh, that one's blank. There is two attorneys because the PD filed a motion to withdraw due to a conflict that was found just in the last couple of days. Yeah.
You write this? Okay. And I don't think I granted it because it's. Someone going to, I guess, address. Because I bond violations.
There is a community corrections report. I was not able to reach Mr. the last couple of days. I know Miss Sack, because the conflict was approved yesterday, and Mac identified Miss Saxon to step in, but it wasn't. The PD is still the attorney of record technically, but Miss Saxon informed me that Mr. Reed changed his number since we last spoke with him, so I have not spoken with him. But it seems like she didn't know that was pending. I did not know. May I see?
Well, how come you haven't been contacting community correction?
My phone had broke.
Because they've been sending alerts and sirens, chief.
Yeah, and I was calling off my mom's phone.
On what?
Mom's phone.
On your phone?
My mom's phone.
You can talk to anybody?
No, nobody ever answered the phone.
Well, that can't be right.
He indicates they did leave voicemail. Could we ask for a moment? And
I think we better, because if that's what he's gonna tell me, I think we might have a problem. So I'll pass it, and can we get a copy of this? Yeah, I'll pass it. You can see it. So, no, I didn't sign the order.
Okay,
That's what you're.
are you going to? I was gonna ask, but I'll stick around.
Is this the only case you have?
Yeah,
It is?
yeah.
So let's see. If I sign the order, then you get to go home and play with those beautiful babies, right?
Well, I got,
But see, I don't get to do that. So this is
man,
all, as you soon understand, about me.
other cases in front of you, Your Honor, that I have to prep for, you know.
For when?
So that's what I will.
I'm off for a week. You got time.
Next week's about to be a busy week.
What?
Next week's gonna be a busy week.
I'm not here.
I know. Can I bring the baby? Play with her? My defense attorney is giving me advice.
Hey.
And I will say, Your Honor, just to explain a little bit, if the court wants, the reason the conflict wasn't found until now is because the conflict's name was not in the police report. It was buried in some video. So it wasn't apparent who the PDs who previously represent. The video wasn't even based on irrelevant to Mr. Reed's case. It just so happened that I was clicking around and found it. So it wasn't anything that was apparent in the police report, and that's the reason.
I don't want me blaming anybody from the PD's office and like going off on them because you're asking for an adjournment on the date of PE.
Right.
I wasn't doing that, so I don't know why you felt the need to cover yourself. Never mind. All right.
I'm reading my record. Thank you.
It's likely that I will grant it. So if you have something else to do, that's fine, because I'm sure one of these other fine public defenders would be able to handle it, just not Chinauza. Okay.
Fair enough. Thank you, Your Honor.
Court recalls the case People versus Kristen Reed.
Good afternoon again, Your Honor. Raymond Cook and people.
Good afternoon again. Stina Saxon for Christian Cook. I'm sorry, Christian Reed.
Okay. What are we doing?
Okay. Your Honor, to address this bond violation, my client's phone broke. He called his mother, who is here, said he was calling a community correction from her phone. Her phone died, and been trying to charge it up to go to her phone provider website to pull up the bill so I could show you proof that on what day and time that they made the attempts to call. He has shown up for every court appearance. Unfortunately, but you know,
I get it, but I don't have any violations because I've not contacted community corrections.
right, he's been complying with the GPS, but they're saying he hasn't contacted since May 26th. And when he called, but unfortunately I can't prove to you because his phone has been broken, which is why PD's office couldn't reach him. And he was calling from mom's phone. That's what I'm trying to get for you. I don't have an iPhone, so I can't charge up her phone to show that. But I personally have left messages with community corrections before, and they don't always respond right away. He's very clear now. I've given him the directive that every time he calls to do a screen print so that we constantly have proof of his outgoing calls.
Charge?
No, I said I do not have an iPhone, so I don't.
No, is it tether charge?
Yeah. Yes. Because it hasn't been going off, so it has been charged. And they're just saying he hasn't called.
No, they're saying they've been sending alerts to the device and he hasn't called.
To call, the way I read it, says sent alert saying call agent, not that he was in violation. It's just that his phone was broken so they couldn't reach him. So for the check-in, they use that as a method of reaching out. So it's not that
how come he didn't go down to community corrections?
He called multiple times.
No, I mean, okay, I'm not getting through to anybody.
No, I understand what you're saying.
Why didn't he go there?
The directive from the GPS was to call in, so he tried calling.
Okay, hold on. You're telling me, tell him to call in. He can't get through to anybody.
And they're not returning his calls.
And so when are you saying he called on mom's phone?
And that's what I'm trying to get for you, but
when did that happen?
The moment that it went off.
In May?
each time he
Every
said,
time. Anytime to make a noise.
but because I know you require proof, that's why I was trying to get the phone statements to show you, because the call log that her call log is only going back to Sunday. So we're having to resort to the phone bill in order to try to get the exact date and time that he called.
Phone log only goes back to Sunday?
Yeah, actually, I'm looking because there's so much activity. You have to change the setting on your phone in order to keep calls beyond 7 days, 14 days. And I've run into this many times. In my experience in IT, I know that is true, that you literally have to change the setting to hold more than 7 or 14 days.
So when's the last time he called?
I can't give you the exact date and time unless I can get to the phone bill. And we need to charge the.
Well, how long is it going to take to get a phone bill?
Your Honor, I was just in here asking.
Online and get a phone bill.
Her phone is dead, and I even came in.
Okay, asked well, that's okay. Somebody's got an iPhone charger around here.
Well, the prosecution.
None of this is making any sense to me.
I asked anybody. I don't have an iPhone and a charger that would fit, so I asked if anybody had an iPhone charger.
Yeah.
And she even tried calling Verizon and got into that loop with trying to get a human.
I see her on her phone right now looking through it, so I'm not sure if charging is the issue.
We've been out asking for a charger. But no, I watched the phone die. And I came in to get my charger.
Right now then.
She must have a charger now.
Sure, charge it.
Miss Reed. Are you on a charger now that has started your phone? Thank you.
What the fuck is
I will say, Your Honor, as you know from your experience, if he was ducking and dodging, he wouldn't show up for every court appearance. And the court would have said that he's complying.
I'm just trying to figure out, did he follow the instructions?
He said he did, but unfortunately,
he's going to be able to get online and get me a copy of the bill. That's going to show that.
That's what we were in the back doing. And because I know you have these other cases, unless you want to pass, give us time to get back on there. Trust that I will have it for you for end of business.
Well, he's going nowhere unless I have proof that he's called.
Okay.
So I think we're going to do it this way. Mr. Allen, you can take him back. I'm going to remand him back. You get me a phone bill that shows the calls, then I'll release it. If not, then I'm going to set his bond and he's going to sit.
Understood.
Court does call the case, People State of Michigan versus Christian.
Good afternoon, again, Your Honor. Raymond Cookton.
Good afternoon, Your Honor. Christina Saxon for Mr. Reed.
On this matter, I hadn't gotten to, there's a request to adjourn preliminary examination, and I may concede to that. However, there's a bond violation report. The record should reflect that the defendant has not contacted community corrections. It's been regarding his GPS and the like. He in court that he made calls to community corrections. There was some issue as to going through the phone and what that was going to show and reveal. But in any event, the court did call community corrections. He's instructed to call the agent, which goes through to the computer as well as to the phone. There is no indication of any calls and or messages from the defendant at all.
Your Honor, as stated at the bench when you were kind enough to give us a bench conference, the phone number to the agent was on paper and misplaced. However, he received the number to community corrections by text. But as stated earlier, his phone was broken. So when his GPS tether bellowed out a phone number, he didn't have pen available. He and his mother, because his phone was broken, Googled Washtenaw County and in an attempt to get to community corrections. I looked at her phone bill, which shows each call. I do see where multiple calls were made to what turned out to be the public defender's office. Unfortunately, a message was left, but they did not return the call saying you have the wrong number. This is who you should call. Furthermore, Your Honor, I would ask, in the face of this potential violation, that because I was just appointed at 2:30 yesterday and just noted bond violation, that you would set this for show cause so that I could get the proper evidence to show that at least attempts were made, albeit to the wrong phone number. He has been compliant every other way. He does have a job. He works at Taco Bell. And again, to my knowledge, this is a matter of a phone call that should have been made, but he now has the number and to lock it in, tattoo, whatever he has to do to not misplace this number again, if the court's not inclined to give us a show cause hearing. As stated in MCR 3.606.
Given that you were just appointed, I will adjourn the preliminary examination to my next date, which is August 18th, 2026, 9 a.m. That is before me. As to the defendant's bond, he has not applied with his condition of bond. Certainly, you may raise by written motion, but I'm satisfied that the defendant had not called community corrections, had not kept in contact with community corrections, despite their attempts to try to contact him. I'm frankly having a hard time believing his story regarding the phone. Certainly could have been that there were calls made. There are no records of any calls made to community corrections, leaving a message to them. As I further had indicated previously, he could have at any given point in time, should it's been a problem, he could have gone down to community corrections and straightened the issue out. None of that did the defendant do. So certainly you may raise and bring whatever evidence before the court that you can find, counsel, that may show or have the court draw a different conclusion on it. But at this point, what I'm going to do is the defendant's bond is hereby ordered revoked. Defendant's remanded.
Your Honor, I'm going to ask that you allow me to withdraw from this matter then, because as stated on previous case, I will be out of the country on the 18th. And so as to not delay his opportunity, and being that I was just appointed.
Certainly you could file a motion. You did indicate that to me, and I don't want to put it out any further than where I have to put it out to.
Right, I don't.
So I'm giving the quickest date possible. If you contact the MAC office, send in a written motion, I will order your withdrawal and new counsel.
Okay.
Does that make sense?
It does.
That way. All right. Okay.
Thank you.
Oh, he love it, bro. That's right. Because we screenshotted the thing and I screenshotted the wrong part of the number. That's why I didn't get.
Ma'am.
Had to Google it. I'm sorry, we didn't know we could come up here and talk to nobody. We didn't know about that because we had a court date and we came to court.
Ma'am.
We didn't figure out that it was a problem. We didn't know it was
If
a
you
problem.
want to listen to me, want to just talk, because I don't have to listen.
I just asked her that so I can explain to you further because she's not explaining it.
Well, that's not true. Council has tried to explain it. She's explained it. I looked at it myself. Council, that when you're talking about council not explaining something to me, you are wrong. This attorney came before me and she's been advocating so that your son did not get locked up. And she has stated all of those things while we were on the phone, because I don't really want to lock your son up either. When we're on the phone talking to community corrections, she's on the phone talking to community corrections. She then came before the court at a bench conference so that she could explain and advocate for your son regarding his release. And then she did it. The problem is community corrections doesn't have a record of it. That's not her fault. So don't sit up there and try to blame her saying she's not doing her job or she's not explaining something to me. She absolutely is explaining something to me. And quite frankly, she's a very good attorney. And the problem is I resent you trying to blame her for what your son didn't do. Bottom line. I've also given her the opportunity prior to the withdrawal so that your son's case was not delayed. She's willing to step off of the case so he can have counsel and he can get before the court quicker. I've also offered her the opportunity to appear to get to this court any information that may change this court's mind. So I'm done, because you know what? I'm done. I'm done. 14A stands adjourned.
Well, that just happened. Oh, yeah. Yeah, that just happened. Oh, my dear goodness. You know, moms, we love you. Sometimes you just gotta let things happen the way they're gonna happen. And stay out of it. Because, especially when you're dressed in black and white stripes, your son does not want to see you going to jail because you're arguing with the judge about what you did and did not copy off of your cell phone. And that was such a lame excuse. Truth be told, the judge had it right. If it were anybody else in the real world and your ankle bracelet were going off, you would immediately get up the next day and be like, going to the actual probation office and like, yo, hey, I don't know what's happening. My phone's dead. I don't know how to handle the situation. Let's work on it together. I'm sure there's a way that we can do it without me having to go to jail. You know, looking up the Google number on your mom's cell phone and calling the public defender's office because you don't have another number to call, claiming that that's enough. Not enough. Not enough. But you know what is enough? I need to say thank you to Specs, Tracy, Natasha, Kitty, Kieran. I need to say thank you to Specs. And I need to say thank you to Specs one more time, because I can't say thank you to Specs enough for all of the super chats that Specs sent in tonight. I got 1, 2, 3, 4, 5, 6 from Specs and 1 from Tracy. Thank you, Tracy. And Miss Natasha, Kitty, all of you crazy cats. You're all wonderful. All you people are wonderful, really. All the chat, everybody in chat. We're going to see Hutch right now. He's got a show going on. It's supposed to be good. Thank you, everybody, for coming out. I'll be doing the same thing. Same wolf time, same wolf channel tomorrow. More court cases. We'll see if they're as crazy as these were. Man, don't play games in court. Never ends well. I don't know what to say. Other than I am your lone wolf Oozle, and I put together these heart-wrenching cases, these cautionary tales for your perusal, for your education, for my education, for all sorts of reasons. Mostly because it brings us all together. And I enjoy seeing all of you here and discussing these cases with you night after night. So hopefully you'll join me again tomorrow night. We'll do it again. Until then, I'm just going to say I'm your lone wolf Oozle. Until I see you next time, I am out. Oh yeah, and my phone is charged. But not my ankle bracelet. I don't have one. And remember, only you can take a bite out of crime. Bye!